Good morning. I will call this public hearing to order. The Committee on Environment, Revenue and Taxation, Labor, Procurement and Statistics, Research and Planning is calling this public hearing to order. It is 11 a.m. on Thursday, March 23rd, 2023, and my name is Thomas J. Fisher. I've been asked to chair this hearing pending the arrival of Senator Perez. In compliance, thank you. In compliance with open government law, notices of today's hearing were published in the Guam Daily Post and provided via email to senators, stakeholders, the local media, and posted to the Government of Guam Public Notices website on Thursday, March 16, 2023, which constituted a 5-day notice, and Tuesday, March 21, 2023, constituting a 48-hour notice, thus meeting the requirements of the open government law. Present with me are no senators, just myself, and that's sufficient. The purpose of this public hearing is to receive testimony on Bill number 57, TAC 37, Committee on Rules, submitted by Senators Chris Barnett, Sabina Flores Perez, and Therese Terlaje, an act to add a new Section 54.25.3 to Part A of Article 9, Chapter 5 of Title 5, Guam Code Annotated, relative to providing temporary expedited procurement protest procedures for acquisitions funded with American Rescue Plan Act monies allotted to the Government of Guam. As in all hearings, today's hearing has certain rules of conduct. Those called to testify will be in the order, beginning with those that either called in advance to Senator Perez's office on Monday, March 20th, 2023, followed by the order according to the sign-in sheet. And I am not aware that anyone called in advance, but I see Mr. Vince Duenas of the Office of Public Accountability is here to testify. Thank you, Mr. Duenas. And Mr. Jarek Hernandez, also of the Office of Public Accountability, is here to provide, both these gentlemen are here to provide oral testimony as well as written testimony in favor of the bill. Individuals testifying shall first be recognized by the chair before speaking and begin by stating your name, organization, and position, if relevant, for record-keeping purposes. And I'd like to wish a very good morning to Speaker Therese Terlaje, who is joining us. Good morning, Speaker. Senators will be given an opportunity at the end of each panel to ask questions. Questions and testimony shall be confined to the substance or nature of the agenda. The personal inference as to the character or the motive of any senator or any individual testifying is not permitted. And we will begin today's agenda. As I previously stated, this is an act to add a new section 54.25.3 to Part A of Article 9, Chapter 5. And as has been said, notices of today's public hearing were adequately published, and notices were also sent to the Director of the Department of Administration, the Chief Procurement Officer of the General Services Agency, the Attorney General of Guam, the Public Auditor from the Office of Public Accountability, and the Director of the Department of Public Works. Along with that, we have received written testimony from both the Office of the Attorney General and the Office of Public Accountability, OPA over the signature of Benjamin Cruz, and OAG over the signature of Doug Moylan. A fiscal note was received on this act, and it was received March 3rd, 2023, from BBMR, and states the proposed legislation could provide an avenue for expedited process in resolving procurement protests, thus eliminating potential barriers that may delay the procurement of goods and services that Government of Guam could avail of prior to the expiration of ARPA funding. However, the Bureau notes that GovGuam department and agencies, inclusive of semi-autonomous and autonomous agencies, must ultimately adhere to the terms and conditions of the respective ARPA federal grant award provisions in this proposed legislation, and I'm still reading from the fiscal note. Provisions in the proposed legislation should not contradict the terms and conditions of the federal award. Gov Guam is in receipt of $1,447,158 and $158,046 in ARPA funds, with about $714,555,696 available as of October 31st, 2022. I'd also like to welcome Senator Chris Barnett, who has just arrived and is, I'm sorry? Thank you. Oh, you're very welcome, sir. We're happy to have you here. And he will be participating in this morning's hearing as well. We have received, as I stated, written testimony from OPA, AG, and I believe we received we got it from OPA. Two people have signed up to testify, Mr. Hernandez and Mr. Duenas. If you gentlemen would like, please come forward and make yourself at home. Okay, and sir, could you identify yourself for the record, please?
Sure. Good morning, Senator Fisher. My name is Vincent Duenas. I am the Supervising Accountability Auditor at the Office of Public Accountability. I'm also the Acting Administrator for the office because the current Public Auditor, BJ Cruz, is off island on personal leave. So I'll be reading his testimony for the record.
Okay, thank you. And are you here testifying in support or?
In support, yes. So
okay,
I'm going to be reading his testimony.
I'm sorry?
I'm going to be reading the Public Auditor's testimony. Yeah.
Very well. And if you would like to proceed, sir, please do.
Sure, thank you. Hafiday Senator Fisher, Speaker Terlaje, Senator Barnett. Thank you for the opportunity to provide testimony on Bill number 57-37. The Guam Office of Public Accountability supports this bill as we understand the urgency to expend ARPA funds before December 2024. Similar expedited procedures were previously in place for procurements funded by the American Recovery and Reinvestment Act, the ARRA, for the Guam Department of Education. We would recommend that the number of days given to the public auditor to issue a decision on the protest be consistent with similar bills related to expedited protest procedures for GDOE ARP-funded procurements, which was 20 days. There were two specific procurement appeals or protests related to ARA that we successfully resolved well within the 20-day expedited timeline, which were the OPA PA 11-008, which was Sanford Technology Group LLC versus GDOE, and OPA PA 12-014, which was Pacific Data Systems versus GDOE. As a compromise, we would recommend at least 15 days from receipt of protest to issue a decision. We would also recommend that all prospective bidders be notified upfront in the procurement solicitation that the procurement is funded by ARPA, and any procurement protests will be taken through the special expedited procurement protest procedures. And then Sinceramente BJ Cruz, Public Auditor. Thank you.
Thank you very much, Mr. Duenas. Mr. Hernandez, did you also wish to testify? Okay, thank you very much.
He's here for support.
Okay.
And should you have any questions related to procurement appeals or anything that we brought him along.
Absolutely.
Thank you.
Thank you very much for that. And at this time, I'd like to turn the questioning of the panel over to our senators, and we will begin with Speaker Therese Terlaje.
Thank you, Mr. Duenas, Mr. Hernandez. All right, and I'm very grateful for the public auditor's testimony. So he's in support of the bill and recommends we change the days. His recommendations I have no issues with. I'm not sure if you were able, but we did receive testimony from GSA against the bill and testimony from the AG against the bill. And so I'd like to try to deal with some of these. Some of GSA's questions are, instead of treating all of ARA funds like this, should we provide a minimum for an appeal instead? In other words, so some of the procurement will be using this expedited appeal basis, but maybe, I don't know, some of the larger ones will not. That was one of the questions. Also, the way she put it, GSA can only respond to the protests. The OPA is handling judge, jury, executioner. Is this not illegal? Will there be a hearing? Who can attend? What happens to the open government law? Maybe you can speak to that.
Sure, no problem. As with all of our procurement appeals or that we do with our office, we do go through procedures. As far as those that can attend, yeah, we actually send it out to the media, all of our procurement appeals, so that anyone can be in attendance. The only thing that I do recall that we do not allow is if there are witnesses, we ask them to step out while the procedures are going on. But other than that, yeah, we do send out all the open government notices, because that's how we plan to treat this, right? As if it was a procurement appeal.
All right, so there is still the same procurement appeal process, but shorter.
Yes.
And then it's the appeal after that that's not allowed. Is that right?
Right.
So then normally, if you don't like your appeal at the public auditor's office, you can go to court. And this says that's where you end, is at the public auditor's office.
That's correct, yes.
All right, and then what about this, these authorities of the public auditor to amend or cancel the solicitation, terminate the contract that was awarded, or declare the contract null and void from the time of its award, or affirm the contract award decision? Are these normal powers of the public auditor?
Let me have Jerry answer that,
Sure.
that question.
Yes, so normally, based on the procurement appeal cases that we have, there have been cases where the public auditor has canceled an award or affirmed an award based on the issues surrounding the cases.
All right, what about canceling a solicitation? Is that possible right now under the current rules?
To my recollection, I think there is.
And terminating a contract that was awarded?
Yes.
All right. Yeah, I think these powers are the same, right? And he's just doing it on an expedited basis, a shorter time frame, and then it's really, the big part is really the appeal.
Yes.
And the goal, of course, was to make sure that we're going to get these procurements done and not get stuck in a court appeal because our ARPA funds will run out. Well, they will expire. And it's really, so those are the trade-offs, right? We lose the funds because we're stuck in an appeal, or we deny the right to appeal and leave it at the public auditor. There is a right to reconsideration, is that correct?
And then, yes, and that was the situation with the ARA-funded projects with regards to GDOE. For the two appeals that were cited, there were final decisions that could not be appealed to the Superior Court. So it's essentially in line with what was done in the past. So that's the reason why we don't see any issue with us applying it. The only difference is now it's government-wide versus just the Department of Education. So.
Correct. Well, that's what this bill would do. So we already passed one for the Department of Education with a 20-day time period for the auditor to issue a decision. Same powers. Now this bill would extend it to the rest of the government who also has ARPA funds to use. Do you think any further protection needs to be added to this bill?
I don't believe so. I think, and to be honest, if you look at the trend of procurement appeals that the office has received, we've actually had a significant decline in appeals to the office. And so we attributed that to the training that's done with the government officials. Like the more training that has been provided, it seems like the number of protests and appeals have declined. And so we, even with this new expedited process, we would hope that that trend would continue, that there wouldn't be much protests, because we've seen a significant drop, at least with appeals at the office.
All right, so the Attorney General's office, I'd ask you to look at his testimony, but he does say, he's concerned about expedited procurement as well, and that he has expedited review of procurement that goes through his office, but he's very much concerned about corruption and how an expedited appeal process will I guess not allow them to pay as much attention to, these things that might be questionable. He says highly questionable. I'm looking if there's any way, any change that we can make while still allowing an expedited appeal, if there's any change that we can make to allay his concerns. It says the bill removes important safeguards in the expenditure of millions of dollars in procurement to the detriment of taxpayers and ratepayers. Using an emergency situation is the first red flag that should prompt more legislative safeguards and not pass laws eliminating critical review procedures needed to thwart white-collar crimes. And he's just talking about the amount of time it takes to investigate what might be white-collar crime or corruption. It says the prior legislature saw a way to avoid needless expenditures of taxpayer resources when they required the AG's office to be directly involved in procurements. In fact, my predecessor abandoned his role by freely giving out the SAAG letters, Special Assistant Attorney General, to practically every department and agency that wanted them. We even had to search our own files when I took office to find and revoke all of them so that we restored accountability to this elected official, AG. Balance to the procurement system is now being restored. Bill 57 gives back to those directors, general managers, and boards the ability to freely engage in procurements without the government's watchdog's ability to stop a bad procurement before it is finalized. Does this bill forego the review of the AG's office?
No, to me, or in our reading, it does not. I mean, this is just merely talking about the procurement protest process, which is has nothing to do with the actual procurement itself.
Okay, so the AG, we know, is supposed to review procurements above a certain amount, and if you review them not just as to form, but that they follow the procurement law. And I know that they are paying clear attention to that. So I'm not, I guess I'll discuss this some more with him. I want to make sure we don't do anything about that process. We want that process to remain intact. That's between him and the agencies, making sure that they are procuring in what they believe is according to the law. All right, is there anything in this bill that allows a public auditor to say, for the two parties, one party, you're right, maybe this solicitation was done in error. However, we are going to proceed anyways with the award because of the interests, best interests of the government.
Yes, that is allowed by law, but of course there has to be, of course, concrete evidence to support the best interests.
What have you seen so far used as the evidence of the best interests of the government?
They have tried, one of the more recent cases had to do with Simon Sanchez, and unfortunately the best interest was not granted because I guess the public auditor didn't feel it was enough to support the best interest award. So that's one case I can recall that the best interest of the government was also brought up. Another one had to do with, I believe, GMH with CT scanners. And I think in that case, I believe the award was affirmed because of the best interests in the government. So
And what did they say? How did they describe that? It was the best interest of the government, because we're pretty much saying to to kind of violate the procurement law in this case because of what?
I can't recall the exact details
All right.
regarding the affirmation of the contract, but obviously it had to do with health, regarding the public
Yes.
health, and so I
right.
think there was enough evidence to support that.
Could you just do me a favor? But just because I've heard contractors, they're concerned about that, right? And can you just maybe compile and send to us a list of cases where that was used, that power? To
Yeah, I
say
can tell you there's not many that the best interest was affirmed.
Okay, good.
But there are several cases, I think, that where it was tried to be brought up, but it was not.
Okay, so when you find them,
Yes.
let me know
Okay.
whether affirmed or denied, and if affirmed, what was the reason?
reason,
Yeah.
okay.
Thanks, I appreciate that. Thank you, Mr. Chair.
Thank you, Speaker. I'd like to turn the floor over to Senator Chris Barnett for any questions he may have.
Thank you, Mr. Chair. Thank you, OPA, for your testimony. As usual, Speaker Terlaje took all the good questions, very thorough. Not really sure there's much of anything left for me to ask. Yes, sir? I did, looking at BBMR's comments here, are you aware of any provisions in this proposed legislation that contradict the terms and conditions of federal awards using ARPA funds?
Not to my knowledge, but that's something we can look into.
Thank you. And also looking over at testimony from Claudia S. Ray. Oh, she got married. Chief Procurement Officer. Is it illegal for the OPA handling this to be the judge, jury, and executioner, in your opinion? I mean, I'm pretty sure she means that figuratively, I hope.
From our standpoint, like I said, this was done with GDOE, with the RF funds, so there's precedent set, so.
Yeah, that's interesting. We didn't get testimony from the Attorney General. What was your, did you have a chance to review his testimony?
No, we did not.
It's pretty juicy. I'm just going to read a little piece of it here. He says, this office is in opposition to Bill 57-37. Guam law currently includes a check and balance in the expenditures of taxpayer resources for procurements. This legislation weakens the ability of the government of Guam to protect against both negligence and potential corruption in the purchase of goods and services. I know you had stated on the record that you don't believe that this measure compromises the Attorney General's ability to review the procurement process.
That's correct. I mean, we haven't had read the testimony, but based on what you were reading, it appears the issue is with the procurement, timing of the procurement, not necessarily the protest process.
Right.
And the bill that is before us and what we testified on and are in support of is regarding the procurement protest procedures, not the actual procurement itself.
Thank you for that. Are you aware, does the Attorney General have any involvement at all in the protest and appeal process?
So the Attorney General does represent several of the agencies during the procurement appeal process, so they would be responsible for providing sometimes the procurement record, the agency report, and of course representing the agency during the procurement appeal cases.
He goes on to state in his testimony that this bill is a legislative step in the wrong direction. The prior legislature saw a way to avoid needless expenditures of taxpayer resources when they required the AG's office to be directly involved in procurements. So you're confident in the OPA's ability to vet anything in the protest and appeals process, right?
Yes, and again, we just go with the precedent that it was done with ARA for GDOE. We knew that the only difference with this one is it's going to be government-wide now. So that's the only difference.
Thank you for that. And you know, I got to say the impetus for Senator Perez and I introducing this measure was actually happened during the public hearing for the measure that we had just passed in the emergency session relative to GDOE being allowed to avail of the expedited protest process for purchases with ARP and ESF funds, and I had asked the panel president at that time, which included the public auditor BJ Cruz and acting superintendent Judy Wampat, and also procurement Jedi attorney John Brown. It was quite a hefty panel of procurement experts, and all three of them had testified that they felt, well, I think Attorney Brown's words were, what was good for the goose is good for the gander. And the public auditor said that this measure is something, obviously, that he would support, and I think that's reflected in the testimony. And acting superintendent Wampat, who had authored legislation that pretty much, I mean, mirrors what we're trying to do here, but with the ARA funds back in the day, also supported it. So again, I just want to reiterate my appreciation of your office's support, and just one more time for the record, the concerns that are raised by the AG. I know you didn't get to vet the testimony, but from what we've discussed here, you think that we're going to be okay?
I believe so. Like I said, based on the precedents of ARA and our handling of that, I believe the OPA is capable of handling additional protests that may be coming from our ARP-funded procurement, but for the rest of the government.
Let me just ask one last question. So after the expedited process is completed, if the AG were to see any red flags, do you believe there's anything that prohibits him from taking action?
I don't believe so.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Senator Barnett. Was there anybody else in the room that wished to provide testimony? And that is a no. All right, thank you, Mr. Duenas, and thank you, Mr. Hernandez. So nobody else wants to offer any testimony, which is fine. No, I do not have any questions. I'm going to turn the mic over to Senator Barnett to offer a closing statement if he wishes.
Thank you, Mr. Chair. I think everything that has been said in this hearing has been adequate enough. I would defer to Speaker Terlaje. No, she's good. Okay. So thank you again for your time, and thank you, Mr. Chair. Appreciate it.
Certainly. If there are no further testimony or comments on Bill number 57-37, Committee on Rules, the bill has been duly heard. The committee will continue to receive written testimony until 4 p.m. on Friday, March 24th at 2023. From the close of this hearing, whichever is later. Please address all testimony to Senator Sabina Flores Perez, Chairperson, Committee on Environment, Revenue and Taxation, Labor, Procurement and Statistics, Research and Planning, and can be dropped to the mailboxes at the Guam Congress Building or emailed to office@senatorperez.org. The committee will now adjourn. The time is now 11:28, and thank you all very much.